Dear students, dear aspirants, hello and welcome to this video lecture series on behalf of Project SATHEE. I am Dr. Animesh, and today we are continuing our discussion on offences against women. We discussed the part 1 of the same entitled the topic rape in the last lecture, and today we are discussing some other offences that impact women that are included in Bharatiya Nyaya Sanhita. This is the fifth lecture of our third module. So without any further ado, let's begin with our discussion. Yes, now sexual intercourse by deceit. Now this is a offense that has been introduced recently in the Bharatiya Nyaya Sanhita. Now, to understand this, a simple situation we can imagine that there is a particular case in which a boy promises a girl that he will marry her. And on that promise, on the basis of that promise, that girl agrees to have sexual relationship with that boy. And later on, the boy, after sexually exploiting the girl, literally says that, see, I don't want to marry you. In that case, this is also obviously a very disturbing case of fraud, disturbing case of deceit. And that is why it has been made offense in Bharatiya Nyaya Sanhita. Earlier, these cases were considered rape, which had its own problem, because many a times the cases in which a romantic relationship turned sour, like the couple was in a relationship and then they broke up. Now the girl, obviously, sometimes she's enraged by that particular breakup, sometimes the breakup is not mutual. In that cases, it is considered that this particular provision, this particular instance was portrayed as rape, and a case was filed on the boy to actually torture him or harass him like that. So in order to prevent that from happening, a new provision is added under BNS which clarifies such instances. Now this particular provision, section 69 of the Bharatiya Nyaya Sanhita, says that sexual intercourse by deceit. Now deceit is a very simple term. It means that if a person with with an intention of actually cheating, deceit means if I promise someone something, or I say something to someone while knowing that what I am saying is false, making a representation, saying something, knowing that what I am saying is false, or making a promise without having an intention to keep it. That is called deceit. So if deceitful means are used in order to take consent from a woman for sexual relationship, that consent is not considered valid within the meaning of this section. Although that act will not fall within the domain of rape, because the girl consented nonetheless. But her consent was taken by, not by force, but by deceit. Deceit means धोखा देकर consent लिया. And deceit means you are saying something which is untrue, or you are making a promise which you don't intend to keep. In that case, it is considered as deceit. So if a consent of the woman for a sexual act is taken by deceit, then it is an offense under this particular provision. It is not considered as rape. If the consent is taken by force, obviously, if the girl's consent is not there at all, in that case, it is rape. So the person will be convicted for rape. But in the case where a man makes a girl some lie in order to get her consent, or makes a promise, generally that is a promise to marry. It can be a promise to marriage without the intention of fulfilling it. Similarly, many a times a girl is bribed, or with the promises of employment, promotion, or most important, this is very common, that is happening all across, by suppressing identity. People lie about their name, what they do, or what their faith is. Recently, we had a case that was reported in the news, that there's a particular person who was portraying himself as Major Harshit Chaudhary of Indian Army. He portrayed that I am a major in the Indian Army, and with this particular identity, he made a profile on various dating and marriage websites, and he had relationships. He promised marriage. Obviously, a person who is an Indian Army personnel is regarded highly in the society, and what we can say, they are eligible bachelors. And on the basis of this representation, he actually he was contacted, or he contacted many girls who intended to marry, who had the intention of marry, and then this person, by giving the promise of marriage, sexually harassed multiple women. And later on, when the police reached to him after a particular complaint, it was revealed that neither the person is a major in the Indian Army. He was a soldier who was dismissed from the army, nor his name was Harshit Chaudhary, and he also lied about his religion or faith. So this particular tool, this particular modus operandi is used by many people to trap innocent women by lying about their identity, lying about their social status, with their religion, whether they are married or not. This often happens. That some people who are already married with kids, they portray themselves as single man to women, get them to fall in love, and then they sexually exploit that woman. Sometimes they end up getting married, and the girl then discovers that this person, not only he has lied about his name and his identity, religion, but rather also about the fact that he's already married. In those cases, which are sometimes motivated by various other factors, sometimes it's purely for the um, exploitation of women, sometimes it is part of a bigger plan. So obviously, if a person, by suppressing identity, making a false promise, or simply when the person does not intend to keep the promise of marriage, then then the action falls within this provision. That is a crime, and it is punishable by 7 years of imprisonment, I believe. Now, what this does not include, it does not include a case where the parties intended to get married, but afterwards they change their mind. Suppose there is a boy and the girl, they were intended to get married, they were a couple, they boyfriend girlfriend, and they had a relationship with each other, and everything was going fine. And when the promise was made by the boy, he actually intended to get married, but obviously relationships turn sour over a period of time. Sometimes they work, sometimes they don't work. So often those love relationship, people fall out of the love, and the relationship break. But that does not mean that the person has committed offense under this section. The prosecution will have to prove that this person never had any intention of marriage. Now, this can be proved by the fact that he was already married, or he knew that the marriage between these two people is not possible, or if the girl actually wanted to get married, she constantly asked for a commitment, or she wanted to get married, but this man was reluctant, or he used various what you can say, excuses to get out of that. So all those conducts can actually indicate that whether he was deceitful or not, whether he actually wanted to get married to that girl, or he was just promising her that okay, we'll get married in order to have sexual relationship with her. Whether he was just promising her for the sake of promising, or he actually wanted to get married. If the court finds that this relationship was genuine in the beginning, and later on they fall out of love, or something happened, the circumstances changed, and now the relationship is not working and the relationship turned sour, in those cases, that act, or the whatever sexual relationship the couple had, will not amount to an offense, or will not amount to a sexual intercourse by deceit. Because deceit is only when you make a promise without having the intent to fulfill it. If at the time of making the promise you had the intention of fulfilling it, but later because of some facts your mind changed, that will not make your promise deceitful. अगर आप प्रॉमिस करते समय आपकी इच्छा थी कि आप उस प्रॉमिस को पूरा करना चाहते हैं, but later you were unable to fulfill it, that does not mean that you have used deceitful means. And obviously, if a person suppresses identity, that amounts to deceit, irrespective of the fact. If somebody lies about his name, where he's from, what his faith is, all those things are very important. So you will see a number of cases in which this suppression of identity is used to sexually exploit women, and it's also used sometimes for other illegal smuggling, illegal conversion, all those activities we see all the times in the newspaper. So this is a new provision that has been added by the government. So this is very important. BNS introduces this provision. Moving on. Now this is again a very interesting topic: outraging the modesty of a woman. Now, outraging the modesty has a very simple definition and a very wide definition. It says that it says assault or criminal force. It is mistakenly written off, but it's assault or criminal force. Primarily, it talks about criminal force. Now, what is criminal force? Now, criminal force is when somebody uses force in a criminal way. Now, force, what is force in the law? Force is simply applying the by bodily power, by the using your power of your body. If you actually move something, you create a motion, you change the motion, or you simply seize the motion, you stop the motion. That is called criminal. That is called force. It means that bodily, by using the bodily power, you move something or you stop a moving thing. That is called force. Now, a force becomes criminal force when the intent behind using that force is either creating fear to someone, like I simply show a danda to someone. That is obviously assault. That is the use of criminal force. Then it can cause pain. If I use the force, I hit with someone with danda, that is also force. Or I create annoyance in the sense that, like we're talking about, outraging the modesty of a woman. So if somebody by his own bodily power uses his bodily force to actually outrage the modesty, see, women are obviously, they have that modesty in the sense, obviously this offense is only can be committed by a man. So if a man actually outrages the modesty in the sense that makes her uncomfortable or simply violates her sexual autonomy. Simply understand, if a person touches a woman in a way that a woman does not want to be touched, that is considered as sexual modesty, that outraging the modesty. Now, outraging the modesty always has sexual overtures, meaning thereby that if somebody slaps a woman, now that person obviously has committed the crime, but that will not constitute outraging the modesty, because he's not slapping that woman because she's a woman. He might have some other enmity. They might have some property dispute. So if a man attacks a woman or hurts a woman, that in itself will not constitute offense under this section. In order to constitute an offense under this section, what is required, very importantly, is a use of criminal force with a sexual connotation. If I want to sexually abuse that woman, then only I will be convicted of outraging the modesty. If I suppose used criminal force on a woman, but my intention was just to hurt her, in that case, I have committed the offense of hurt, uh, and an appropriate punishment will be given, but I will not be punished for outraging the modesty. So here the intent becomes very important factor, and the intent has to be gathered from surrounding circumstances. If one man, see, many a times you see, this is a very unfortunate problem in our society, that the women in tight spaces, in buses, on street, people, obviously those who have perverted mind, they try to touch women in a very inappropriate way. They touch parts of the woman's body that the woman does not want to be touched. You know, we have that idea for the children. We have this idea of good touch and bad touch, and we teach that children because children don't have that sense, but grown-ups do have that sense. That if a person is touching a woman on any part of her body that is inappropriate, that obviously constitutes outraging the modesty. So if a woman feels annoyed by that thing, and the person has sexual intent, in that case, it will be considered a crime and the person will be punished for outraging the modesty of a woman. Generally, 3 years punishment is there for that. 3 years imprisonment punishment is that. So what is important? Some type of force was used. Obviously, it created annoyance for that woman. And secondly, there was a intent on the part of the offender that she wanted to touch that woman, harm that woman, abuse that woman in a sexual way. I was just trying to say, if somebody hits with a danda on a woman's head, that might be a separate offense, but that is not outraging the modesty, because there is no sexual connotation to hitting a woman with a danda on the head. But if a man gives even a slightest touch to a woman's body in a sexually inappropriate way, that constitutes outraging the modesty. Obviously, it is a smaller form of sexual assault or rape that we discussed. That is a more heinous form, but this is somebody grabs a woman, grabs her posterior, grabs her breast, or anything like that. That constitutes outraging the modesty. Moving on, sexual harassment. Now, sexual harassment, these particular provisions were added after the Honorable Supreme Court said in the case of Vishakha. Vishakha judgment is a very famous judgment which talked about sexual harassment at workplace. And obviously, after Nirbhaya incident, all these amendments were made. So it's these provisions are a culmination of these two judgments. One judgment is obviously Nirbhaya incident, not judgment, Nirbhaya incident, and there was something called Vishakha judgment, which gave guidelines towards sexual harassment at workplace. There is a separate legislation for that. Prevention of Sexual Harassment of Women Act, POSH, what we call Prevention of Sexual Harassment. Now, what constitutes sexual harassment? Obviously, the first point is unwelcomed and explicit physical advances and overtures. If a person tries to get close, he tries to get close with a particular woman, when such closeness is unwelcome, if a woman is not willing, if that is making a woman uncomfortable and a person is constantly trying to be close with her, that constitutes sexual harassment. Now, this does not require use of any criminal force or even touching the woman, but the person might come very uncomfortably close. He might make physical advances, try and constantly coming close to her, or even ogling her constitutes, constantly looking at a particular woman. That also constitutes sexual harassment, because even a person who is longingly looking at a woman, now that can make a woman uncomfortable. So unwelcomed and explicit physical advances. If a person makes such he gives such gestures that are explicit and improper, that constitutes sexual harassment. This is a very important thing to understand. Now, obviously, this is what constitutes sexual harassment and what does not constitute depends on the circumstances. Who is the man, who is the woman, what is their relationship, whether there are many things which are considered acceptable in a particular setting but not acceptable in another setting. Okay. So suppose I am close friend with someone, and I with a lady, and obviously I put my hand around on her shoulder. If I am a good friend of that woman might not take offense. And that particular advance does not have any sexual overtures, and neither it is unwelcome. It is fine. You can put your hand on the shoulder of a particular girl if you are good friends with her. But suppose on a random woman who I do not know, and I simply go and try to be extremely friendly and put my hands over her shoulder, that may constitute sexual harassment. So the very difference between sexual harassment and a consensual act is how uncomfortable that makes a woman. It is not about what you intended. It is about how a woman felt. If that makes her feel unwelcome, in that case, it is considered sexual harassment. But if she is fine, if you have that kind of relationship, that's perfectly all right, no problem. What may constitute harassment and what constitutes friendly, The difference is how it made the woman feel. That is the core point that you have to keep in mind. Second point is obviously a demand or request of sexual favor. You cannot make unwelcome demands about sexual favors. Now, this is specifically sexual harassment if the person is a colleague or is in a professional relationship with that woman. Such a demand or request for sexual favor is considered sexual harassment at any point of time. And there is no defense to say, ki, sir, I asked nicely. Some people take that defense, okay, I asked for sexual favors, but I asked her nicely. I didn't force myself on her. No, you cannot ask a woman for sexual favor, even on social media, even personally, on her DMs or whatever the case may be, because that makes a woman uncomfortable. So it is considered sexual harassment if a person makes a demand or request for sexual favors. This is inappropriate. Third, showing pornography against the will of the woman. This is very clear that why this is sexual harassment, because obviously showing pornography to a woman who is not willing, now that constitutes the most bizarre form of sexual harassment, because obviously any sensible person with even little bit of sanskar won't do that act. Say, watching or showing or distributing pornography is a separate offense that is inappropriate. So sorry. Yes. So distributing pornography, it's in itself is a problematic thing, but showing it to a woman, and that too against her will, is very problematic. It's considered a very depraved act, so it constitutes sexual harassment. Now, making sexual colored remarks. Now, this is essentially about catcalling and speaking. Sometimes people try and do an innuendo. There is a concept in taught called innuendo. Means you are making a reference without making a reference. If you are trying to be clever about it, see, if you say something directly, that may constitute a crime, but you try to be clever and you speak about something that is innocent, that is not related, that's not sexually, but it has a sexual connotation. People use that terminology, and there are a number of examples. Obviously, you all can understand how people use sexually colored remark. That everybody who is listening to that or reading that will understand that in what context it is used, but apparently looks innocent. So that is something what we call it is a sexual harassment. If a woman is catcalled, if a woman is said, "Chalti hai kya 9 se 12," it's very simple. It means you are asking her to go with a cinema hall or to his place or whatever the case may be. In that case, it is considered as sexually colored remark. That's very appropriate. So if a man makes that, and recently there was a controversy about the honorable member of parliament from Himachal Pradesh, Ms. Kangana Ranawat ji, a particular opposition leader and another leader from another party, unfortunately a woman, said that, okay, the constituency of Kangana Ranawat ji is Mandi. So it was written that what's the rate in Mandi? Now this is sexually colored remark. Now she's comparing, uh, she's playing with the two meaning of the term. That is something what we call sexually colored remark. If a man would have said that, that would have been offense. But unfortunately, a woman said that, so it was not considered an offense. Okay. And obviously, she denied. She said that her account was hacked or whatever the case may be. But sexually colored remarks, that can be considered as an example of sexually colored remark. So anybody who says that has committed an offense of sexual harassment. Now, the first three of these sexual harassment have a punishment of 3 years, while making sexually colored remark, it has a punishment of 1 year. The maximum punishment is 1 year, making sexually colored remark. So all of these constitute sexual harassment. And sexual harassment in general. Now, there is a very separate provision for sexual harassment at workplace. That obviously we'll take a brief session on POSH as well in later, so that you get an understanding of that. But as of now, we move on to some specific kinds of sexual harassment. Now, sexual harassment one is disrobing a woman. Disrobing a woman is using criminal force to actually disrobe or take the clothes out of the woman, or compelling her to be naked. In that, compelling her to strip, not completely naked even. So that will constitute an offense of disrobing. So suppose if a woman is wearing any cloth and a person tries to disrobe her by taking any cloth out of her body, like if a woman has taken dupatta and somebody simply takes that dupatta from her body, that also constitutes an offense under this provision. Disrobing a woman is simply whatever article of clothes she has on her body. If you forcibly compel her to take that off, but it should be an article of clothing, not something else. Like many a time while frisking an examination, the people who are trying to prevent unfair means, they ask women to remove the extra layer of clothing, or like suppose she has a muffler or something. Sometime in order to prove the identity, if a woman has a veil, a ghungat or a niqab, the persons, in order to establish the identity, will ask to remove that. But that does not constitute disrobing a woman, because obviously the intent, the sexual intent, has to be kept in mind. If a woman's clothes are teared, her t-shirt or whatever clothes she is wearing, if she's stripped of that, that constitutes disrobing a woman. That's a serious crime. But if something is not an article of clothing, it's an extra layer of covering, she's covering the face or something like that. In that case, if she's asked to remove that for the purpose of identification or for any other legitimate purpose, that does not constitute disrobing. Else, pulling the archal of the sari also constitutes disrobing. So if a man pulls the archal of a sari of a woman, that constitutes disrobing within the meaning of this provision. Or compels her to be naked. Obviously, if they says, okay, you strip or something will happen to her, that means compelling her to disrobe. That is also considered sexual harassment. Okay. Now, second is a very interesting provision, that is about voyeurism. Now, what constitutes voyeurism? Now, voyeurism comes from a French word voyeur, means to watch. So, anybody who watches a woman, the simple definition of voyeurism is, it's a long definition in Bharatiya Nyaya Sanhita, but I'll simplify it for you. If somebody watches a woman or captures a woman's image, either watches her or captures her image at a place or at a time when she has an expectation of privacy or she does not want to be watched, in that case, it is considered as voyeurism. Means if suppose a woman is taking bath anywhere, if she is using lavatory, if she's changing clothes, if she's taking a bath at a river, a lake, or a pond, or whatever the case may be, if she's at such place, suppose she's sleeping in her bedroom, all these cases, she has an expectation of privacy, that I am not being watched. You know, or if she does not want to be captured in that place, when she's in solitude in her home, obviously I stay in a different uh, attire or in a different situation when I'm at home. When I walk out, that is a different case. So if woman has an expectation of privacy, in that case, anybody who watches her or captures her, in that case, it is considered voyeurism. Okay. Obviously she without her knowledge, that is the case, or without her consent. If you are there with the woman's consent, that is not voyeurism. But obviously, when she has an expectation of privacy and somebody breaches that privacy to watch her or to capture an image of her, that is considered voyeurism. Some places, but in normal world, obviously, if a woman is walking on street, she does not mind if somebody watches her, or taking pictures is even fine when she has an expectation to be clicked. And I suppose a woman, a girl, she gets ready for a marriage, or she's obviously has an expectation of getting clicked. She is very enthusiastic about getting her picture. All of us are, obviously. if you are ready. But obviously, in some places, she has an expectation of privacy. So anybody who watches her or captures her picture in that case, or this is very important, if he watches or captures a picture, in that case, that person has committed voyeurism. That is true. But anybody who disseminates that image is also considered guilty of this offense. Means suppose a woman जो है, she captures herself, or she's captured with her consent or without her consent. If even she wants to get captured, or she wants to, she is willing, or she consents to capturing of a picture, but she does not want it disseminated. So anybody who disseminates it has committed the offense of voyeurism. See, even if a woman sends a picture of her to someone which is intended for only him, so if that person uses that picture and disseminates it, that person has committed an offense. Or anybody who disseminates that picture has committed an offense. This is very important to understand. So people who share explicit picture of women who are sometimes taken without her consent, or sometimes it is taken with her consent, but she does not want to disseminate it. In that case, anybody who disseminates that picture and sends it to another person has committed the offense under this provision. So this provision is very important to protect the privacy of a woman. If she does not want to get watched, nobody can invade her privacy. If she does not want to get her pictures taken or a video taken, that is the right of the woman. Anybody who breaches that privacy is guilty. Even if, but suppose she captures herself in an inappropriate setting, if she is if her body is exposed, her breast, her posterior is exposed, or her sexual organs are exposed, or she is involved in a sexual act, what you don't do in public generally, obviously. If she is involved in any private act using lavatory, if anybody disseminate those pictures, if a woman is well dressed in a professional attire, and I share her picture in a proper attire with someone, that's not an offense. Voyeurism an offense if a woman gets her picture clicked, even if she wants to get in a position when she has a reasonable expectation of privacy. In an inappropriate picture, you cannot disseminate. I can obviously, somebody has, if a particular girl has a Facebook profile picture, now I send that Facebook profile picture to someone. Now this is not an offense, because whatever her profile picture is, she wants it to get disseminated. That's why it's a profile picture. And obviously, presuming that her profile picture, the image that is there is not an image of a private nature. So in that case, voyeurism has to be understood in that sense. Okay, I hope that makes it clear. Obviously, the punishment can extend up to, for first offense, it can be 1 to 3 years. For second offense, it can be 3 to 7 years. So some people have this particular tendency of watching women. Those are considered peeping Tom. That is a term that is used in America. So if that is the case, that's a very serious offense, and we should all be very cautious about it. And we should actually spread this information, give this information to women, that if anybody has taken your picture without your consent, or somebody is trying to blackmail you, or somebody is trying to disseminate that picture, that's a serious offense and should approach the law enforcement authorities. Last but not the least, stalking. Stalking very simply means following a woman. Unwelcomed pursual of a woman is stalking after she has shown her disinterest. Now, stalking can be either actual, real, if you are following a woman physically, if she's wherever she goes, you go, that constitutes stalking. Or if you follow her in social media, in the sense you stalk her, means you monitor her, her over the internet, that also constitutes stalking. Writing nice pic there on every picture, now this is a bit exaggeration, but if a person tries to track all the internet uses of a woman, tries to follow her across social media, despite her disinterest, keeps on messaging her from various websites keeps calling her from different numbers. This is called stalking. Once a woman has shown her expressed disinterest in establishing contact with that man, it is immediately a warning to back off. If a woman is not interested in you, if you keep following or pursuing her, that constitutes stalking. That's an offense, and a person can be sent to jail for that. There are very small exceptions to it as well. Exception is when the person is actually stalking it for the benefit of as a law enforcement agency. Obviously, if a woman has some sensitive government information and a police person feels like she is selling it to some other country, or there's a law enforcement logic to it, then obviously it is fine to spy on a woman. That can be done. If the law enforcement agency, if she's a suspect in crime and she's followed, that is fine. Or if she's fined for her own protection, if she's stalked for her own protection, suppose a woman is under threat and a law enforcement officer is trying to protect her. Sometimes it happens if lonely street a woman is going and the police person says, okay, fine, you go, I'll follow you so that you reach home safely. That is considered as okay. Or when it is expedient to do that, lawful to do that, that does not constitute stalking. Sometimes stalking is necessary when a particular woman is mentally ill or she is depressed. So sometimes stalking is for the benefit of the person. I believe that many people who commit suicide, if they were stalked, they would have been saved, unless until the stalking itself is the reason of her mental troubles. If she is, you should stalk your loved ones, for their own protection. You should actually keep care, and that is obviously not unwelcome. That should not be unwelcome. Sometimes you get irritated when your parents call you every hour, say, where are you, whether you have eaten or not. But that is out of love, and you will feel, if that is not the case, then you will feel very insecure. So that is something very important to understand. So stalking, the intent behind stalking is a very material thing. If you want to establish contact when the woman is expressly disinterested, in that constitutes stalking, even on social media. But if if a woman is pursued for her own benefit, for the benefit of law enforcement, or some other legit justification is there, then that is not considered as stalking. So the sexual harassment has four legs. Some instances of sexual harassment we discussed, and then other offenses of disrobing a woman, voyeurism, and stalking we have discussed. So this concludes our discussion on crime against or offenses against women. In the next video, we will talk about kidnapping and abduction, which is again a very interesting topic. So I'll see you in the next lecture. Thank you so much. And if you have any doubt, please reach me at Animesh. And obviously, in the next topic, hurt and grievous hurt is also a topic. So we'll continue with that. So thank you so much. I'll see you all in the next lecture. Keep learning.